Well, good morning. I'm Jagender Rana. The product for discussion today is Public Liability Insurance Act 1991. Public Liability Insurance Act 1991. The advent of the Industrial Revolution has brought about the social impact of accidents in manufacturing plants. With the evolution of sophisticated manufacturing product lines and use of hazardous chemicals, the risk for human is high. According to the recent report published by the National Disaster Management Authority, 130 major chemical accidents have been reported in the last decade, resulting in 259 deaths and 563 injuries. So, majority of the people affected due to such industrial accidents are found to be from the economically weaker sections and suffer huge financial hardships as they get delayed relief and compensation. Our workers of industrial units are protected under Workmen Compensation Act 1923, but there is no such protection for the affected public. We are aware that worst industrial disaster in the world happened on a cold winter night in the early hours of 3rd December 1984 in Bhopal. Nearly 25,000 people died in that incident and lakhs of people were injured. A need to enact one statute law was felt by the Government of India after that event. The Public Liability Insurance Act 1991 has been enacted and effected from 1st April 1991. So the object of this act is to provide through insurance immediate relief by owners to persons affected due to accidents while handling hazardous substances on no-fault liability basis. That is, claimant need not be required to establish that the death, injury or damage in respect of which the claim has been made was due to any wrongful act, neglect or default of any person. The definition of owner includes any firm or its partners, associations or its members, company or its directors, and all other persons associated and responsible to the company in the conduct of their business, and also covers any person who owns or has control over any hazardous substances at the time of accident. At the time of accidents. So, according to Section 4(2)(a) of the PLI, Public Liability Insurance Act, insurance policy is to be purchased by owner for an amount up to the paid up capital of the undertaking but not exceeding rupees 50 crores. But as per Rule 10 framed under the Act provides that the maximum aggregate liability of the insurer to pay relief under an award to the several claimants arising out of an accident shall not exceed rupees 5 crore, any one accident. And in case of more than one accident, during the policy, the currency of the policy shall not exceed rupees 15 crore any 1 year in the aggregate. So, in case of claim exceeding this statutory limit, it is to be met by an environmental relief fund set up under Section 7(a) of the Act and managed by the authority appointed by the central government. The liability beyond the total insurance and the relief fund is to be borne by the owner. Environment Relief Fund is created by contribution of equal amount of premium charged and collected from the owner by the insurance company. So, Schedule of Compensation under Section 3(1) of the PLI Act 1991 provides relief as death. Quantum of relief per person is only 25,000. Additional actual medical expenses incurred per person is 12,500. Permanent total disability again rupees 25,000. Additional medical expenses 12,500. Permanent partial disability amount of relief on the basis of the percentage of disablement as certified by registered medical practitioner plus medical expenses 12,500. Temporary partial disablement which reduces the earning capacity of the victim. Fixed monthly relief not exceeding rupees 1,000 per month up to a maximum of 3 months provided the victim has been hospitalized for a period exceeding 3 days and is above 16 years of age. Medical expenses rupees 12,500. Actual damage to property up to rupees 6,000 and no medical expenses applicable. Now the question is, how to get relief under this Act? Under Section 6 of the PLI Act 1991, an application for claim for relief to be made in prescribed form to the collector of the district within 5 years of the occurrence of the accident by the person or legal representatives of the deceased or by the owner of the property damaged by accident. So on receipt of application, the collector would hold an inquiry into the claim and make an award determining the amount of relief and specifying the person to whom such amount of relief to be paid. Thereafter, the collector arranges to deliver copies within 15 days from the date of award, and insurer deposits the amount within a period of 30 days from the date of announcement of award. The collector would arrange to pay from the relief fund in terms of such award and in accordance with the scheme made under the Act to the claimants. Now in 2008, the central government has notified and established the Environment Relief Fund scheme known as ERF scheme, and United India Insurance Company Limited was appointed as its fund manager. The funds existing in the custody of various insurance companies at the time of notifying the scheme was transferred to ERF scheme, and subsequently the same insurance company remains fund manager. The contribution collected from the owner at the time of collection of premium by the insurance companies are transferred in the ERF scheme. The fund manager is obliged to submit the annual statement of accounts on the management of funds to the central government. The quantum of this fund as on March 2019 was over rupees 800 crores. So when the Public Liability Insurance Bill was introduced in Parliament and when subsequent amendment bills came up for discussion, a key suggestion was to increase the amount of relief. As a matter of fact, this relief amount is negligible when compared with the present day expenses as well as the quantum of relief provided and there are other type of accidents. So let us examine the provisions of a statutory law pertaining to liability under the Motor Vehicle Act 1988, Workmen's Compensation Act 1923. The benefits relief are also on no-fault liability basis. The Motor Vehicle Act 1988 have been revised in 2019. Nomenclature of Workmen's Compensation Act 1923 has been changed to Employees Compensation Act in 2009. So with increased benefits, and benefits have again been revised apart in 2020. Let us discuss the provisions of the quantum of liability. So only for death and permanent total disablement under these two acts. Under no-fault liability of the Motor Vehicle Act 1988, death benefit was rupees 50,000 and permanent total disablement was 25,000 in 2019. It has been increased to 5 lakh for death and rupees 2,50,000 due to permanent total disablement, that is quantum of compensation has been increased to 10 times. Means for no fault liability it is 5 lakh for death and 2,50,000 for permanent total disability. As far as the scale of compensation under Workmen's Compensation Act 1923 varies with the age, last drawn wages before the accident and relevant factor. One multiplier varies with the age provided under the Act. So compensation is derived multiplying that factor with the last drawn wages by the employees before the accidents. Under Workman Compensation Act 1923, maximum wage is considered to calculate the compensation for death was rupees 4,000. It was revised to 8,000 in 2009 and again revised to 15,000 in 2020. So with the increase of wages, compensation amount has also increased. Accordingly, at present the compensation for death, permanent total disablement and other benefits have been increased nearly by 4 times. So to increase the quantum of relief, taking a cue from the above introspection, it is of utmost importance to enhance the relief fund to relief under different contingencies of PLI Act at least at par with the no-fault compensation provided under the Motor Vehicle Act 2019. A broad revision of indemnity limit once the quantum of relief per person is increased. Insurance coverage is required to be increased suitably for AOA limit and AOY limit. Widening the scope of the Act, the selective use of transportation by vehicles exclude transportation of hazardous substances by other modes like air, railways and ships. So the Act should include transportation by all such modes. Ensuring compliance, the Public Liability Insurance Act administered by the Ministry of Environment, Forest and Climate Change will monitor and ensure that industries handling hazardous substances purchase this insurance. Creating digital awareness campaign help increase the level of compliance. In addition to that, information on status of PLI Act insurance should be available in the website of the respective organizations handling hazardous substances. So it has to be kept in mind that PLI Act is a piece of welfare legislation and its purpose is to provide prompt and adequate relief to the persons suffering from such accidents. Modifications of Public Liability Insurance Act 91 is the need of hour, because as on date the limit of compensation is very meager, that is only 25,000 rupees in case of death and permanent total disability, and lower than that in case of permanent partial disability and temporary partial disablement. So this is of course not adequate amount for the relief to the victims. It should be at par at least with the limit of no fault liability applicable to the Motor Vehicle Act 1988, which was revised in 2019, where the limit has been increased to 5 lakh rupees in case of death under no fault liability and 2,50,000 in case of permanent total disability. Thank you very much.